I hope this is Reno High. We'll go ahead and briefly introduce ourselves, then we'll go through your introductions, and then we'll go ahead and read the question and go from there. My name is Jim Leslie. I'm an attorney in Reno, and I practice in civil and criminal law for about 20 years or so.
My name is Richard Siegel. I have spent my entire life as a political science professor here at UNR and on the board of directors of the American Civil Liberties Union.
I'm Taylor Snell, a recent graduate at the university and currently interning with the Governmental Affairs Consulting Group.
We'd like to thank you for judging us today. I'm Alexis Fisher.
I'm Tyler Ward.
I'm Elise McMurtry. I'm Daniela Tappan, a teacher is Mr. Clark, and our unit coach is Mr. Carlin.
All right, Unit 1, Question 2. Unit 1, Question 2. What are the fundamental characteristics of a constitutional government? In what ways does constitutional government mean limited government? Describe at least 3 provisions of the Constitution that provide a means of preventing abuse or misuse of governmental power, and please explain how these provisions work in our system of government today. Please begin.
In Federalist 51, James Madison claimed, in framing a government which is to be administered by men over men, the great difficulty lies in this. It must first enable the government to control the governed, and in the next place oblige it to control itself. In essence, a constitutional government must promote the classical Republican idea of general welfare, while having limitations to protect natural rights.
The fundamental characteristics of a constitutional government are that it derives from the consent of the governed and establishes an uncodified or codified body of laws that can be altered. The United Kingdom's unwritten constitution is based on multiple founding documents, common law, and judicial precedents. The basis for individual rights to privacy is seen in Chief Justice Edward Coke's statement that the house of an Englishman is to him as his castle, which comes from Article 9 of the Magna Carta. This later influenced an English court decision of Entick versus Carrington, which defined trespassing.
In a codified constitution, however, such as that of the United States, all powers are expressed or implied in one document. The basic structures of all 3 branches of government are enumerated in Articles 1, 2, and 3, but can be altered through Article 5's amendment process to make a more perfect union. This ideal emanates from John Locke's second treatise of government, which promoted that for government to exist, the governed must consent to a social contract with their rulers. To enact such a contract in the United States, Article 7 outlined the procedure for the ratification of the Constitution.
By upholding higher law and providing for a separation of powers, a constitutional government becomes limited. Higher law exists to ensure that all constituents, regardless of social class, follow the law of the land. In the 39th article of the Magna Carta, the rule of law was developed and was enforced on all British subjects. The Supremacy Clause reads, "This Constitution shall be the supreme law of the land."
Thus, every individual and institution in the United States must abide by federal law. Furthering the idea of government limitation, Barry de Montesquieu asserts in the spirit of laws that without separation of governmental powers, there is no liberty. Federalist 47 carries this idea into state governments. By dividing power, it is less likely to be abused by one individual. This idea can be extended to incorporate checks and balances among governmental branches to prevent the abuse and misuse of power.
Provisions in the Constitution set forth guidelines for the central government so that power can be used moderately to make, execute, and justify laws while providing for the interest of the public. The Commander-in-Chief Clause and the War Powers Clause allow the executive and legislative branches to check one another's military power. With the War Powers Resolution of 1973, Congress tried to assert its power, but this measure has been ignored until September of this year when President Barack Obama asked Congress for approval for the military strike in Syria.
Congress is prohibited from suspending habeas corpus except in justified cases, as established in Article 1, Section 9. While the Military Commission Act held that the Great Writ could be suspended for Guantanamo prisoners, Boumediene versus Bush declared this unconstitutional. Article 1, Section 2 and 3 set the term of office for United States Congressmen. These provisions keep Congress members' intentions focused on their constituents' interests, because it is their constituents that we elect them. To further check congressional power, Mississippi Representative Stephen Palazzo has proposed a limit to the number of terms congressmen can take, so that they must return home to live by the laws they create.
The 2010 Nevada ballot included a referendum for creation of an appellate court. These legislative referendums limit the laws state governments create based on the consent of the governed. Through referendum, states become, as Supreme Justice Louis D. Brandeis observed, laboratories of democracy, checking the central government through federalism. Thank you.
Well, thank you for that initial presentation. As you know, we'll go to some follow-up questions, and we'll begin on my left. Rich.
Yeah, excellent starting statement. One of you mentioned John Locke, and John Locke reminds me of the word revolution. And he had a revolution in his day that he was writing about, and we've had revolutions related to the American Revolution, the Civil War, and people have used that term for the Civil Rights Revolution, called the Civil Rights Revolution of the 1960s. And you know we have revolution now in Syria and Libya recently and so on. So what do you understand revolution means, and how has our own constitutional understanding of the term revolution and the actual use of revolution evolved?
Well, John Locke said that the right to revolution is basically in the form of being able to alter or abolish the government that you live under.
Also, as you said, the civil rights movement could be seen as a revolution in thought. And because the First Amendment provides for freedom of expression and freedom of speech, freedom of the press, and freedom of religion, all kinds of revolutions of thought can go on today under our Constitution. For example, the gay rights movement can be seen as a revolution in thought.
I would like to agree with Elise too, because in Article 5, our founders set up a way for amendments to be added in the Constitution, and thus provide for a way for a revolution of thought to occur.
Looking at specifically the Civil War, the southern states were declared in a state of rebellion, other than revolution, and with the thought of secession, which is different than revolution, but similar in the United States perspective, the Civil War was declared unconstitutional by Texas v. White.
So would the Supreme Court be as understanding about revolution in 1795 as in 2013? Would our Constitution, without having been amended, would the Supreme Court be taking a different view of the right to revolution?
Continuing with the revolution of thought idea, the Supreme Court has seen multiple revolutions of thought throughout its existence. For example, in Dred Scott versus Sanford and Plessy versus Ferguson, it ruled against the rights of African Americans. However, in Brown versus Board of Education, that was overturned, and they declared that the African Americans deserved equal protection as well as other people under the Constitution. They used the 14th Amendment in that regard, and therefore the Constitution continues to provide for such revolutions of thought today.
Would you repeat the question, please?
Well, I'm really trying to, one additional thing I'm trying to get to is the Supreme Court's approach to violent revolution. Would there be a difference? Think of the Whiskey Rebellion, think of anything that has occurred in the United States in the area of violent riots and so on in the last 30 years. Has this been an evolution of the unwritten Constitution, or has there been mostly continuity?
If you look at what John Locke was trying to say about revolution, he clearly defined revolution as the last resort of getting rid of a government. And in the Declaration of Independence, it says, with the long use of usurpations, it is the right of the people to abolish a government that is going against their rights, what they believe to be their rights, and the common good of the people. And with things like the Whiskey Rebellion, it was only a small minority of the people who believed that their rights were being infringed. And so this revolution could not happen because there wasn't a majority of the people who believed the same thing that they did. So the United States was still firm on the thought that they could not revolt because of certain laws, or certain things as taxes on the farmers.
I'll leave it at that. Let's move on.
Cool. So you mentioned the Civil War and there was habeas corpus, and Lincoln famously suspended habeas corpus during the Civil War. So in that sort of vein of thought, do you think some rights should be given more protections than other rights?
One thing we can see that the Supreme Court has decided by substantive due process is protection of fundamental rights, rights that are so unalienable from someone that they must always be protected. For example, in DeShaney versus Winnebago County, we saw that the court decided that the government cannot infringe on someone's fundamental right on how to raise their children.
However, fundamental rights should be protected, and there are other less fundamental rights that don't deserve as much protection. For example, the Second Amendment protects the right to bear arms. However, there was just yesterday another shooting in Colorado and an attempted bombing in Kansas, in a Kansas airport. And arms is so difficult to define today than it was when the Constitution was written in 1787, that right deserves less protection than more fundamental rights.
So if they could make a nuclear weapon the size of my wallet, do I have a solid argument that that's my form of self-defense? It'll only blow up 2 or 3 city blocks, and I want to make sure that I'm safe and it's small, and I'll keep it well hidden, and I'll keep it in a safe so my kids can't get to it. I mean, is that just an absurd argument, or as we get to the point where weapons become so small and so capable of being used by individuals, do we kind of curve back on itself, and do we really have to legitimately debate who gets to have these things and who doesn't? Is it a goofy question, or talk to me about it?
I think that it's an absurd situation because in Amendment 4, Amendment 2, the right to bear arms cannot be taken away from someone, but at the same time, there must be a well-regulated militia. And a well-regulated militia does not go with, for example, your wallet-sized nuclear weapon, because we must protect the general welfare as well.
Could you tell me more about fundamental rights? I'm glad you raised that. So what would be 2 or 3 good examples of the fundamental rights that the Supreme Court would be most invested in?
Well, another fundamental right is the freedom of speech, which is protected in Amendment 1. Voltaire once said, I don't respect what you're saying, but I will forever fight for your right to say it.
Another fundamental right could be a mother's choice to have an abortion. Roe versus Wade protected this because a mother should be able to control her own body as a natural right.
Also, go ahead. In Lawrence v. Texas, the court decided that the government cannot infringe on an individual's right to privacy in their own homes.
Why are these rights fundamental? I mean, you told us that they are recognized as being fundamental, but what makes them fundamental? What's the thought process behind that?
Fundamental rights are seen as so simple that it's almost impossible for the government to have a say in these kind of things, like what someone wants to do in their home. Unless there is a camera inside your house watching you 24 hours a day, they don't have the right to say what you can or cannot do in your home.
In your bedroom.
In your bedroom, specifically.
Living room is fair game.
Yeah, where would you say these authorities for these like inalienable rights come from? Like, where would you guys keep bringing up Locke, and it's awesome. Where would Locke say that authority for those laws come from, or those inalienable rights?
Locke would argue that inalienable rights such as life, liberty, and property are yours until they possibly take away someone else's life, liberty, or property, such as in situations where if someone is threatening your life or coming at you with some type of weapon, you have the right to use deadly force on that person to protect your own life.
William Blackstone also believed that fundamental rights and natural rights can be interpreted to God-given reason, and he determined natural law to be a God-given law that people could interpret in constitutions as they saw fit.
Well, then this segues to one of the camp questions we were going to throw at you. How did religion influence the founders' belief about government? And if you can, draw a distinction between religious belief and what kind of belief may have influenced their view of government, and the distinction between that and between religion and maybe some of the experiences they were trying to avoid.
Well, in the third article of the Articles of Confederation, the government had to provide public education for the country. And in colonial experiences, in New England especially, the ability to read was imposed on all citizens, especially by Massachusetts law in 1642, because they wanted people to reflect the virtues that were in the Bible.
Going back all the way to ancient times, Socrates was executed for not complying with the religion of his city. And later in the English government, many religions such as the Puritans were oppressed. And when people came from England over into the colonies, they carried this history with them, and therefore they wanted provisions in state constitutions as well as the national constitution to provide for freedom of religion.
Was there a difference in terms of the concept of the established church? Was there a difference between the country before the American Revolution and after the American Revolution? Was there a major difference in whether it was constitutional to have an established church?
And you have 4 seconds to answer.
Wow.
So no, go ahead and give us a couple of quick comments.
Well, in the colonies were originally, they all came over with colonial charters, and most of them they belonged to the same religious groups, and so that's all.
I think you're on the right track.
When you look at colonial America, many of the colonies were based off of different religions, and they only allowed certain establishments of religion in those colonies. But when they came together as a united country, they decided that every person should have a say in what kind of religion they want to do. So they decided that no established government or established religion should be put on to the United States.
In addition, Maryland was one of the few colonies that provided for Catholicism, and many state constitutions in their Declaration of Rights said that they would provide for Christianity to be practiced in the conscience of the person, however they chose to practice it. However, the actual Constitution provides for all freedom of religion, not just Christianity.
And on that inclusive note, we will have to end since we're beyond time. Thank you for that presentation.